Morning, morning.
Good morning, Mr. Commissioner, members.
Yes.
Mr. Commissioner, we are ready to proceed. This morning we will start with evidence from the regulatory authority, the FSCA, and I plan to call two witnesses. The first is Ms. Nonku Tsombe, who's the head of the legal department.
What's the name?
Nonku, N-O-N-K-U, Tsombe, T-S-H-O-M-B-E.
T-S-H-O?
M-B-E.
M-B-E.
There is also a written presentation submission before the Commission. My next witness, Ms. Felicity Mbasu, will deal with this. The purpose of the evidence of Ms. Tsombe is just to give the Commission a proper historical background of what happened in the past couple of years with regard to the regulatory framework.
We don't have a statement from it.
It's not necessary. It will be very brief, 5 to 10 minutes, Mr.
Okay.
Commissioner. And with your leave, I will ask her to.
Your full names?
My full name is Nonkumbulo Chombe. Sorry?
I didn't hear the second name. You said Nonku?
Nonku.
Oh, Nonkumbulo
Yes.
is the whole name.
Yes.
Okay. Chombe.
Yes. Chombe.
Chombe. Do you have
TSH.
any objection to taking the oath, Ms. Chombe?
None whatsoever, Commissioner.
Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated.
Thank you, Commissioner.
Thank you, Mr. Commissioner. Put on, okay.
Yes.
Mrs. Tsombe, you are the head of the legal department of the FSCA. Is that correct?
Yes, I am.
What is the FSCA?
The full name is the Financial Sector Conduct Authority, established in terms of the Financial Sector Regulation Act, which came into effect on the 1st of April 2018.
Now, the purpose of your evidence is just to enlighten the Commission of the historical background of what happened before the FSCA came into being.
Yes, sir. Shall I start?
Yes, please.
Okay, thank you. The FSCA is the successor of the FSB, the former FSB, which was the Financial Services Board. Financial Services Board has been in existence as a regulator of the non-banking financial services since it was established by an act that came into effect in 1990. The Financial Services Board has regulated the non-banking financial services in terms of from a prudential and also a conduct perspective. With the 2008 financial crisis, the Financial Services Board, together with National Treasury, etc., the whole country, started a financial regulation journey that culminated in the Twin Peaks mode of regulation, which was established via the statutes that I referred to earlier, the Financial Sector Conduct, the Financial Sector Regulation Act, which came into effect on the 1st of April. Now,
I think you must just explain to the Commission what you mean by the Twin Peaks approach.
The Twin Peaks approach really encompasses, in simplistic terms, the separation of regulation of conduct from that of regulation of the prudential activities of the financial services industry. So currently, the Financial Sector Conduct Authority now regulates all the financial services entities that are under its regulation from both a prudential and a market conduct perspective, whereas, it regulates them only from a market conduct perspective, whereas the Prudential Authority, which is an entity within the Reserve Bank of South Africa, it regulates the prudential activities of financial services industry. I hope that is clear.
Please proceed.
Perhaps I could just add a point that, just to be clear. Previously, there was a separation, and I think this is where the Twin Peaks makes the difference, that you had banking regulation, which included conduct, market conduct within the entities that the Reserve Bank and bank supervision dealt with, and then your FSB also dealt with the prudential regulation of everything else, your stock exchange, your insurance companies, and so on. Whereas now your market conduct includes conduct of banks.
Yes.
Which is different. So you have the market conduct looking at the conduct of banks, as well as the conduct of all other entities, and the prudential regulation looking at that side, including non-banks.
Yes.
Yeah.
Yes.
Thank you, Mr. Commissioner.
Thank you, indeed. Having, by Twin Peaks, I think we've now explained what the difference is. The Financial Sector Conduct Authority, can I please, with your leave, Commissioners, can I call it the authority so that I don't have to think? The authority currently regulates, as we speak, regulates the conduct of all financial services, including banks, via the old sectoral pieces of legislation which were used by the FSB during its conduct. Obviously inclusive now of the pieces of legislation that focus on prudential activities, because the FSCA, the authority, regulates the banks as well, but only from a conduct perspective. Are
you able to give us an indication of these pieces of legislation? How many are they?
Yes. Can I just name a few? Well, not a few. I'll name almost all that I can remember now. We're talking here the Long-Term Insurance Act, the Short-Term Insurance Act in the insurance area. We're talking the Pension Funds Act in the retirement industry area. We're talking the FICE, which is the Financial Advisory and Intermediary Services Act in the financial service provision area. We're talking the Financial Markets Act in the capital markets area. We're talking the Friendly Societies Act in friendly societies. We're talking the Financial Institutions Act, once again in the financial services area, financial service provision area. We're talking the Inspection of Financial Services Act. Can't remember if there's anyone that I'm leaving out, but anyone that I'm leaving out is probably quite marginal. But those are the main statutes that the FSCA and previously the FSB used to administer. So, having introduced Twin Peaks via the FSR Act. Sorry?
Yeah, one.
Yes.
The banks, which act sort of regulates the bank's conduct?
That would be, I think, if we look at it now, we'd be looking at the Banks Act. But the Banks Act, to the extent that it talks into prudential conduct, that will be the function of the Prudential Authority. But as we speak now, there is an extensive piece of legislation which is called the Conduct of Financial Institutions, which is under discussion, which will now delve deep into proper regulation of all the various areas of regulation by the FSCA. That piece of legislation has not yet been assented to, is not yet an act, but is at advanced stages of discussion. This is why I had to explain that currently the regulation is taking place still via the various sectoral pieces of legislation that were used before Twin Peaks came into being. Okay. So once Twin Peaks came into being and the authority became established, it was necessary for the authority to have a leadership. And at that stage, being a new entity, basically the FSCA, the leadership of the authority had to be sourced. Advertisements had to be made, and that process was provided for via regulations that were promulgated by the minister. I think they came into being on the 29th of March, 2018. Now, the process of getting that leadership into place is still on course. And at the time, the regulations then set up a transitional leadership structure for the FSCA. That transitional leadership structure is made up of, in terms of the regulations, is made up of the commissioner, a commissioner that has been appointed as commissioner transitionally, and within that leadership structure, which is called the Transitional Management Committee, within that transitional structure, the executive committee of the FSB was appointed, but appointed as at that stage. In other words, the executive committee of the FSB as provided for in the provision in Section 9 of the FSB Act. And then there was an extra member which was appointed as an expert by the Minister of Finance. So that's now the transitional structure that is leading the Financial Sector Conduct Authority until the commissioner, the statutory commissioner, and the deputy commissioners are appointed. That process is still on course.
Just a question in relation to that, thank you, is that the name of the commissioner that is the interim person, that is Mr. Abel Sithole, is that correct?
Yes. Can I say something about that?
Please
just to put it into context? The FSB was governed by a board, and Mr. Abel Sithole was a chairman of the FSB board. Now, the transitional in terms of the regulations, the transitional structure was required to disestablish the FSB and to establish the FSCA with the least disruption in terms of operations. And in terms of those requirements, the leadership that was chosen was to have Mr. Sithole as the commissioner and the FSB EXCO, as well as a ministerial appointment. One person was a ministerial appointment as an expert in market conduct.
Sorry, can we just ask who that person was that was appointed by the minister?
That's Ms. Catherine Gibson.
Catherine Gibson?
Yes.
And I don't question the motivation behind the steps taken, but from the point of view of this commission, the question becomes that Mr. Sithole is the commissioner for the transition, but he also is the CEO of the Government Employee Pension Fund. It's the same Mr. Sithole that we're talking about.
Yes.
And therefore, from the commission point of view, we just need to bear that in mind, that the GEPF in relation to the commission fulfills a different role as distinct from the FSB, which is a regulatory role, which should be looking at the GEPF as well. So there's just a little bit of what I would think is a conflict or grey area that needs to be taken account of. Obviously, it may be different in relation to the fact in when it was set up as distinct from what appears before this commission that we have to look at in relation to that.
Okay. If I may make just a comment on that, Lady Commissioner, the GEPF is not regulated by the FSCA. And the FSCA regulates the PIC, the GEPF not, and the board of the GEPF, the board of trustees of the GEPF, is actually the governing structure of the GEPF. the principal officer, if I may also just put the right terminology, Mr. Sithole is the principal officer of the GEPF, which is different from a CEO in the traditional sense. So being a principal officer and being a CEO being two different things, and also having the board being the actual governing structure of the GEPF, and also the GEPF not being regulated by the FSCA at all. The FSCA regulating the PIC. I don't know if that's of any assistance. I hope so.
I think it does help, but it doesn't necessarily resolve the conflict, because in essence, using the words of the principal officer, the GEPF, and I'm talking about this specifically in relation to this commission's work.
Yes.
I'm not talking more broadly, because obviously the Financial Sector Conduct Authority regulates the PIC. We're looking into the PIC, and the GEPF is the major client of the PIC. So given the same personality, all I'm doing is pointing out that there is a gray area in relation to Mr. Sithole. I'm not questioning what was done in relation to creating the regulatory authority.
I will not question that, Lady Commissioner. I leave that to the commissioners. I just needed to set out the legal requirements and the legal framework.
But for my interest and purposes, what's the difference between a principal officer and a CEO?
A principal officer is actually defined in the Pension Funds Act. I don't know if any of my colleagues have the Pension Funds Act. I don't have one with me now. So it's not quite the same as the work of a CEO. The principal officer is actually a kind of a liaison officer between the board of a fund and the members, let me say, of the fund, of any fund, as well as the employers that contribute to that fund, members that contribute and the employers that contribute to the fund.
Which would mean that person then sits on the board.
The principal officer is actually a permanent invitee of the board. The principal officer as such is not a member of the board, but is a permanent invitee of the board. I think so, unless they've got questions. I just want to ask if they've got any questions. Commissioners, I don't know if at this stage there's anything further that you'd like me to explain. I think in terms of setting out the framework, the legal framework, and the relationship between the FSCA, the FSB, the GEPF, and the the PIC. I would imagine that I've said my piece, unless there are any other questions.
If I can perhaps just sum it up, it was put to me, I think in quite practical terms, that the role of Mr. Sithole is that of the undertaker of the FSB and the midwife of the FSCA. I think that explains it beautifully.
Just to be clear, is that the GEPF doesn't fall under the Pension Fund Act?
No. The GEPF has its own establishing legislation, pretty much like the PIC has its own establishing legislation. So it's not under the Pension Funds Act. Yes.
Thank you, Mrs. Tsombe. Mr. Commissioner, can we just rearrange the chairs for Mrs. Mabasu to take?
Felicity Mpho-Mabaso.
Second name, Mpho.
Mpho, yes.
Do you have any objection to taking the oath?
No objections, Commissioner?
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? Raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated.
Thank you. Mrs. Mabasu, is it correct that you are the divisional executive of the FSCA?
Yes, that's correct. Divisional Executive for Licensing and Business Center.
Thank you. There is a written submission prepared dated the 15th. Is that correct?
Yes, that's correct.
Can you please start with that, paragraph 1? You will be asked questions by myself and by the commissioners during your presentation. Are you comfortable with that?
I'm very comfortable with that.
Thank you.
Thanks. From paragraph 1 of the introduction. Okay. Your request of 8 March 2019 for the Financial Sector Conduct Authority to provide specified information to the PIC Commission of Inquiry refers. The FSCA came into existence on 1 April 2018 with the advent of the Financial Sector Regulation Act 2017. The FSCA took over the functions of the Financial Services Board and the various registrars responsible for the administration of the sectoral legislation, more specifically in the context of the PIC and the Financial Advisory and Intermediary Services Act of 2002, the Registrar of Financial Services. In this letter, references will be made to the FSCA, the FSB, or registrar as may be applicable at the relevant time. In anticipation of the appearance by officials of the FSCA before the Commission on 18 March 2019, the Commission is provided with high-level background information regarding the following: the type of license issued to the PIC, supervision of the PIC over the period January 2015 to December 2018, complaints received against the PIC, and the level of compliance by the PIC with laws administered by the FSCA. Authorization of the PIC. The PIC is wholly owned by the South African government with the Minister of Finance as shareholder representative. The PIC was established on the 1st of April in accordance with the Public Investment Corporation Act 2004. And Section 4 of the PIC Act requires the PIC to obtain a license in terms of Section 7 of the Phase Act. The PIC was approved by the registrar on 6 December 2005 to conduct the business of a Category 1 FSP and Category 2 financial services provider in respect of the following financial products.
You don't have to read that out.
Okay.
If it is
Thank
all right
you.
with you, Mr. Commissioner, they're specified in the columns.
Well, I thought this was my chance of knowing what these documents are.
You're going to have it, Mr. Commissioner. Will you please read it into the record?
Yes. And explain them, please. I mean, I know what shares are, I know what money market instruments are, but the rest I don't.
Yeah.
Thank you.
If I may, Chair.
Yes, please go ahead.
Sorry, I'm just trying to get her to give me the
Fine.
definitions. We have shares. PS is approved for securities and instruments and shares, and it can be listed or unlisted shares. And then we have securities and instruments. Those will be money market instruments.
I'm sorry to interrupt. I think what the Commission is looking after is for you to explain under securities and instruments, for example, what is warrants, certificates, and other instruments.
Okay, all right.
Can I? Can you please talk about what we mean by CAT 1 and CAT 2, you know, because it's quite...
No,
quite
I'll
something
definitely
that,
get to that
and
point.
And then the advice part and the
intermediary services part,
yes,
I'll take you through that,
yes,
I'll provide the necessary information. Okay. If I may, I just want to check with my colleague here. Apologies, we just want to.
I think while they're looking for that, okay, there it is. Just press the button.
Sorry, Chair, as I say, we don't have some of the definitions here. So if I may, I'm going to ask if it's okay, with your permission, some of my colleagues to speak to some of the instruments and give an explanation of those instruments. Okay.
Perhaps you can assist by talking to the Category 1 and Category 2.
All right, I can do that. A Category 1 FSP is an FSP who offers advice and render intermediary services without discretion. So advice means any recommendation, guidance, or proposal of a financial nature furnished by any means or medium to any client or group of clients in respect of the purchase of financial products or in respect of the investment in any financial product.
Where do you get that from?
It's a definition from the legislation.
Which legislation?
From the FAIS Act, Financial Advisory and Intermediary Services Act.
And maybe explain discretion also, discretionary.
So discretionary FSPs means an FSP who renders intermediary services of a discretionary nature regarding the choice of a particular financial product. So in the context of PIC, it simply means that PIC having full discretion or having entered into full discretionary mandate with all of its clients has the freedom to decide or make recommendations and decisions about how or where the client's funds or assets will be invested or must be invested. And that is, of course, within the parameters of the client's objectives that are prescribed in the different mandates. And having said that, we should always keep in mind that the Code of Conduct requires of every provider, a financial services provider, to at all times render financial services honestly, fairly, with due skill, care, and diligence, and in the best interest of clients and the integrity of the financial services industry. Though they have the discretion, that discretion must be within the limits of their client's objectives, taking into account the Code of Conduct.
But who then ensures? Is it the FSCA ensures that the honesty is there and everything else is there in the application of a client's funds?
Yes, it is the FSPA who's supposed to make sure that there is honesty and integrity when it comes to dealing with clients' assets. I mean, a supervision of the conduct of financial institutions means that, it focuses on the fair treatment of customers by financial institutions, including the protection of, customers' assets and funds against any theft or any fraudulent activities or irregular activities.
And how often does your organization or institution do that? How often do you do oversight to find out whether there is no fraud and so forth?
We do oversight in different forms. It's coming up, yes, on this. Yes,
Okay.
yes, it is. Okay. Paragraph 9. Okay. The PIC manages exclusively on behalf of the public sector entities, manages assets exclusively on behalf of the public sector entities. Its clients are said to be pension funds.
Sorry, let me take you back.
Yes.
What are debentures and scrutinized securitized debts?
Yes, it's securities and instruments, Mr. Commissioner. I just want to make sure that my colleagues at the back put together the right definition so that I can read it out for the record. Okay.
We're looking at that now.
Yes.
They're going down the list.
Yes, we're going down the list, and then I'll revert back to those.
Thank you.
Okay, and okay. So I was on paragraph 9. The PIC manages assets exclusively on behalf of public sector entities. Its clients are said to be pension funds, provident funds, social security funds, and guardian funds. The PIC invests primarily in fixed income, equities, properties, and developmental projects. The FSCA's records indicate that the PIC has 22 clients with whom it has entered into full discretionary mandates.
I have asked you a list of those clients, but I believe there is a confidentiality clause in the statute. But it would be correct, as you've pointed out, that these clients are pension funds, provident funds, social security funds, guardian funds, etc.
Yes.
And we know from previous testimony that who are the major clients of the PIC, for instance, the GEPF.
Yes, that's correct.
Thank you.
The authorization of the PIC allows it to render advisory services, intermediary services, and discretionary intermediary services to clients in respect of the financial products listed in the above table.
Would it be correct to say that the services with regard to a Category 1 FSP is very limited when it comes to the PIC?
Yes, because it has entered into discretionary mandates with all of its clients. The PIC, as an authorized financial services provider, is subject to, inter alia, the General Code of Conduct for authorized FSPs and representatives, and as well as the Code of Conduct for discretionary FSPs. Paragraph 5 of the letter Code of Conduct.
Question?
Yes.
Can you please talk more about what an FSP is? Because there's quite some difference between a company and FSP and all that.
An FSP is a financial services provider that renders financial services on behalf of entities in respect of the financial products that we've listed in the table that we're presenting here today.
So someone, or call it an entity, that lends money for me to buy a car, would that fall under FSP?
At the moment, if there's an element of insurance as part of that transaction, because sometimes you buy a car and the same dealer would also sell insurance to you, then that dealer would need approval as an authorization as a financial services provider in respect of that insurance. However, the credit aspect of the deal will be dealt with by a different regulatory authority.
Which is called what?
The National Credit Regulator. May I proceed? The PIC specimen mandate was approved by the registrar at licensing stage, and the discretionary mandate affords the PIC full discretion regarding the investment decisions and choice of financial products in relation to clients' investments.
Can I interrupt again? What is meant by specimen mandate?
A specimen mandate is the mandate that is required in terms of paragraph 5 of the specific code of conduct, and it contains just the minimum requirements that the FSPs have to comply with if you are authorized as a Category 2 FSP. And if I may, I will take you through some of those minimum requirements. The mandates, the FSP or the applicant is actually required to have this mandate that will include, amongst other things, the authority given to the discretionary FSP to act on behalf of the client, and the investment. That specimen mandate must make provision for the investment objectives of the client. And it must also contain a general statement pertaining to the risks associated with investing in local and foreign financial products, with particular reference to any currency risk. And it must also stipulate in whose name the financial products are to be registered, and whether they are, for example, to be registered in the name of the client or any nominee company nominated by the client, or a nominee company of the discretionary FSPs, or the nominee company of a products provider. And it also requires of the FSP to make provision in its mandate, for the bank account details of the FSP and the trust account details to be opened at a bank or other bank account opened in the name of the client, in which the discretionary FSP must deposit, and where applicable, from which the discretionary FSP must withdraw monies received in connection with investments. So this is some of the, is a long list. I can go through the list if you want me to, Mr. Commissioner, but it's available.
In what part of the Act is it? What section?
Is the Financial Advisory and Intermediary Services Act, and is the Code of Conduct for Discretionary FSPs, Section 5 of that code. It specifically deals with all the requirements that should be in the specimen mandate.
Thank you.
Yes, and it's just minimum requirements. Okay. The conditions of the license. The PIC is subject to the following license conditions imposed at the date of authorization. And I just want to state here that these conditions are just not imposed in PIC, it's general conditions that apply to all licensed FSPs. The financial services provider must inform the registrar in writing. That was then, because PIC was approved back in 2005, and the FSB was responsible for its approval. So it must inform the registrar in writing by facsimilar or in an appropriate electronic format within 15 days after the change has taken place of any change in respect of the business information of financial services of the financial services provider, as provided in Form FSP1, Form FSP3, FSP Form for FSP 9, 10, and 10A, or FSP 11. Those are license application forms. So if anything changes or the profile of the FSP changes in respect of the information contained in those forms, that must be reported to the authority. And if I may continue, and the second condition speaks to relates to financial services provider must at all times during the currency of the provider's license maintain the services of any key individual or key individuals mentioned in the information submitted on the said application form, and must, as regards changes in respect of such information relating to a key individual or appointment of a new key individual of the provider, in addition to acting also in such cases in accordance with the procedure and time limits set out in Condition 1. Also ensure full compliance with Section 84B of the Act, the provisions of which must be regarded as included in this condition. The financial services provider must, within 1 month of the date contemplated in Section 7 of the Act, submit a copy of the register kept in terms of Section 13.3 of the Act to the registrar, and must thereafter, in accordance with the procedure and time limit set out in Condition 1, inform the registrar of any change effected to the details as contained in that register. The financial services provider must not in any manner change the name of the financial services business as reflected on the license consent, or carry on any financial services business under such a changed name, unless A, the provider has fully complied with the provisions of any other law than the Act which regulates such change of business name, if any, and B, the provider has fully disclosed to the registrar the details of such compliance with such other law, and C, the registrar is satisfied that such change of name is otherwise lawful and has approved such change of name. And lastly, the registrar has issued to the provider an appropriately amended license under the provisions of Section 85(b)(I) of the Act. The financial services provider must at all times ensure that any financial product in respect of which the provider intends to render a financial service qualifies as a financial product contemplated in the Act and is or will be lawfully issued by the relevant product supplier by virtue of an authority, approval, or right granted to such supplier under a law as contemplated in the definition of product supplier in Section 1(1) of the Act. Supervision of PIC over the period January 2015 to December 2018. Statutory framework. The PIC is subject to compliance with, inter alia, the following legislation: the FACE Act, the General Code of Conduct for authorized FSPs and representatives, the Code of Conduct for discretionary FSPs, and the determination of fit and proper requirements published under Board Notice 194 of 2017, which came into operation on 1 April 2018. The board notice sets out the competency standards, that is your qualifications, experience, regulated exams, continuous professional development applicable to all FSPs, including operational ability, a good standing, honesty and integrity, and financial soundness requirement. The 2017 board notice repealed an earlier notice on determination of fit and proper requirements for FSPs published under Board Notice 106 of 2008, which was applicable over the period January 2015 to March 2018.
Can I ask you something in relation to that? One of the points there is operational ability.
Yes.
Would the number of acting positions in the PIC been a question for your consideration about continuity, expertise, cause for concern? Was it ever looked at by yourselves as part of the oversight?
The operational ability in this context will relate to the people or persons that are in regulatory positions. For example, your key individuals, your representatives of the asset manager, compliance officers, and auditors. But other positions that are not regulated in terms of the phase, would not, when it comes to those positions, would not necessarily look into that.
Would you not think that, given the oversight, the capacity, and, at what point in time does a red flag come up about permanent staff, because you're talking about competency, ongoing viability, and so on. I understand that you're looking at the regulatory side, but as a supervisory body, would it not be relevant to see whether there's permanent staff in place or acting positions in place in the organization as a whole? Does it fall under a different category of supervision that you look at?
No, it wouldn't, but when we look at the governance framework of FSPs and the structure of the different committees, then if there's loss of acting positions, we'll interrogate that information to find out why. If there's a risk that there may not be proper oversight of important activities, especially when it comes to investment decisions.
Are you able to say anything about the PIC, about the PIC regarding these regulatory aspects?
Yes, we're actually going to come to that. We're going to comment on the various issues mentioned here. Yes. Yeah. The FICE Act deals in Section 17 and 19 with the submission of statutory returns by FSPs. The submission of statutory returns plays an important part in the supervision of licensed entities. The structural design is such that the preparation of these returns include the involvement of external services providers such as the auditors. FSPs must cause the financial statements to be audited in accordance with auditing pronouncements as defined in the Auditing Profession Act 2005.
In the case of the PIC, the external auditors are the Auditor General, is that
yes,
correct?
That's correct. Compliance reports. Section 17 of the FICE Act deals with the appointment of compliance officers by FSPs. The compliance officer...
I'm sorry to interrupt you. Can you just for the record state who is the compliance officer of the PIC?
The compliance officer of the PIC is Mr. Divilius Makonko. A compliance officer is approved by the authority to render compliance services to FSPs subject to prescribed fit and proper requirements. And these fit and proper requirements include inter alia competency requirements, and there's your qualifications, regulatory examinations, and experience, character qualities of honesty and integrity, and operational ability. Compliance officers are required to submit compliance reports to the FSCA biannually. For the period 1 January to 30 June, the submission date is on or before the 31st of August every year. And for the period 1 July to 31st December, the submission date is 28 February of the following year. The purpose of the compliance report is to determine whether the FSP complied with all applicable regulatory requirements in terms of the FICE regulatory framework. In compliance with the provision of the FICE Act, the PIC has an approved compliance officer.
Sorry, Advocate Libber, perhaps we could get a profile of the compliance officer?
Yes, it will be put before the Commission. Thank you.
Yes. Throughout the relevant period, that is January 2015 to December 2018, the PIC's compliance reports for each of the reporting periods were submitted and received by the FSB and FSCA after 1 April 2018. The compliance reports submitted to the FSB and FSCA over the period in question did not indicate any issues of non-compliance or other irregularities that required regulatory action to be taken.
I'm sorry to interrupt again. Because of evidence already led before this Commission, we know by now that during 2018, there were various reports in the media regarding what is now known as the IO transaction, that the PIC was hauled before the SCOPA in Parliament, Special Committee on Public Accounts, in December 2018. And we had the situation that during this sitting of this Commission, there was a press statement by the PIC that officials in the PIC with regard to the IO transaction flouted policies and procedures of the institution by signing off on this transaction. Now, if I understand you correctly, none of this found any into the report submitted by the PIC to the FSCA.
Yes, and it would have been submitted, in terms of Section 19.4, read with Section 17.1c of the Phase Act, which deals with irregularity reports. So we've never received any irregularity reports relating to the IO transaction from PIC.
And we also know that as early as February 2018, there was an audit query raised by internal audit regarding this transaction. So again, it was not reported to the FSCA.
It was not reported to the FSCA.
Can you proceed with paragraph 23 then, please?
Okay. In terms of Section 19, read with Section 17.1c of the Phase Act, the compliance officer and auditor of an FSP must inform the FSCA in writing of any irregularity or suspected irregularity in the conduct of the affairs of that FSP, of which the compliance officer or auditor became aware in the performance of their functions, and in which, in the opinion of the compliance officer or auditor, is material. The requirement to submit irregularity reports applies to all FSPs required to appoint a compliance officer or auditor. There is no record of an irregularity report submitted by the compliance officer or auditor of the PIC for the period in question. The FSPs are required...
Take something. If there are media reports that show there could be problems, does the FSCA have any power to do something about it if it's not reported by the compliance officer?
Yes, we do. And when we come to on-site visits, I'll unpack it further. I'll provide more information on that. Okay. FSPs are required to submit their audited annual financial statements within 4 months of the financial year end. The PIC is required to submit audited financial statements on or before the 31st July annually. The PIC's audited annual financial statements over the relevant period were submitted and received by the FSB and FSCA. The annual financial statements must be accompanied by a Section 19.3 audit report in respect of money and financial products held on behalf of clients, which confirms at year end the amount of money and financial products held on behalf of clients were kept safe and separate from the FSP's own funds.
So just to make it clear to the Commission, this is a separate report in terms of this specific statutory provision.
Yes.
That must be provided to the FSCA.
Yes, by the Auditor General. Yes. The annual financial statements of the PIC are audited by the Auditor General, and the FSCA's records indicate that the PIC has met the financial soundness requirements during the period in question, and there were no adverse findings.
I mean, we must, I think, also put on record, if I remember correctly, during this period we're talking about the PIC received clean audits from the Auditor General.
Yes. The FSCA utilizes a risk-based supervisory model. On-site visits or on-site inspections referred to now in Section 132 of the FSR Act are planned and conducted on FSPs based on this approach. On-site visits are themed and limited to a specific scope. The scope of thematic on-site visits is informed by, amongst others, trends in the industry, complaints received, as well as the outcome of a desk-based supervision process. And if I may respond to the question that was raised before about what we do, are we doing with media reports, do we take action? The answer is yes, because this on-site visit in particular was also triggered by what was reported in the media in 2017. An on-site visit was conducted at the PIC on 6 February 2018. The scope of the on-site visit was limited to mandate compliance, governance framework, and processes followed to make investments on behalf of clients. Having regard to the scope of the on-site visit, the PIC explained the procedures, processes, and controls underpinning the investment management function. And based on the information provided by the PIC during the on-site visit, the authority did not identify areas of non-compliance with the focus areas prescribed in the scope of the on-site visit.
Can I just ask you for the record, who were the representatives of the PIC that you met during this on-site visit?
Okay. The representatives of the PIC were Dr. Daniel Machila, Mr. Tivilas Makonko, Mr. Paul Magula, Sholto Dolamo, Enes Nesani, Rubina Solomon, Lebohang Molebatsi, Melissa Breda, Leon Smith, Benedict Mongalo, Reabezwi Nosi, Amogelang Mokumi, Lufuno Nema Govani, Katu Nezamba, and Mududuzi Nzibande.
Just for the record again, I don't want to talk about all of them, but Paul Magula was at the time the risk officer.
Yes.
Chief Executive Head Risk. Ernest Nsani was the Executive Head Legal. Mm-hmm. The Compliance Officer was there.
Yes.
And the Head of Internal Audit.
He was also present.
He was also present.
Yes.
Sorry, just in relation to that, how, in hindsight, when you've seen what has come out about, say, for instance, internal audit having reported certain things about non-compliance or non-procedural issues, would you think that there was material non-disclosure to you as a regulator? Have you had a chance to look at what has come out both in the public arena at this point in time, and whether, in fact, it was material non-disclosure or an interpretation of the scope of the on-site visit that limited, and they could say it wasn't part of the scope, we didn't cover that. Have you had a chance to assess that in relation to the sort of public disclosures that have come out subsequent to this on-site?
Actually, following the appearance of the internal auditor before this commission, we sent PIC a letter wanting to confirm the timelines of the IO transaction, because when we questioned the PIC, which was part of the scope of the mandate, whether there were any mandate breaches, we were informed at that point that there were no mandate breaches. So we wanted to confirm when the audit was conducted and whether it was before or after the on-site visit, and when these findings were made, because we only got to know about them when the witness appeared before the commission.
Have you had a reply to that?
We did have a reply, and the PIC confirmed that the audit actually happened after the on-site visit, and I think the findings were made on the 5th of March.
And the question then...
Excuse me, sorry, ma'am, I just want to confirm my dates with my colleague here. Oh, apologies. The findings of that audit were made in May 2018, and they only confirmed to us on the 5th of March. But there was no mention of that particular audit during the on-site visit on the 6th of February 2018.
And then in relation perhaps to that, so you would be satisfied with the response to your letter that they then have fully disclosed the process problem, if you like, or that there was a material finding? Did they would that satisfy you in terms of the reporting required about such a breach, what was contained in their letter?
Yes, we went through the letter and that satisfied us. And I think, like I mentioned, the most important thing was the timelines of this particular audit, because we got very concerned that we were sitting with them in the same room, interrogating the mandate breaches, and it was never mentioned. So they informed us that it happened after, but then at the same time, that was never reported to the FSCA. Though it happened after the effect, after the on-site visit, we never got any regularity report on the particular matter.
And in relation to that, the fact that you never got, even now, have you not got a regulatory report?
We've not received any regularity report.
And therefore, there would be follow-up from your side?
There will definitely be follow-up on our side, because we also following these proceedings. We noting all the information that is coming, from the witnesses, and actually going back to our records to see what was disclosed and when that was disclosed, in order for us to make informed decisions about, what the appropriate regulatory action should be in respect of the people who participated in all these processes, including those that were present in the when we conducted the on-site visits in 2018.
And also, if I could ask you in relation to that, obviously you're monitoring it, if as the FSCA you identify areas of regulatory improvement, would you be willing to make suggestions to the Commission? It's part of our terms of reference as well, to see that we make recommendations about improvements to the system. If you are assessing and finding areas that you think could be improved, you would submit comments to us?
Yes, we will definitely do so.
Thank you.
Thank you. Okay. Based on the information provided by the PIC, I'm on data right now.
I'm sorry, Mr. Commissioner, we're past 11 o'clock, which is a normal tea time. If it's okay with the Commission, can we proceed and finish this witness?
Let's proceed with this lady.
Based on the information provided by the PIC during the on-site visit, the authority did not identify areas of non-compliance with the focus areas prescribed in the scope of the on-site visit.
A question here. Yes. In terms of investment processes, you said you went to the PIC to look at those.
Yes.
Do you sort of, as a first question, do you check the standard, the level of good practice of those processes, as a first question?
Mm-hmm.
The second question is, do you have a way to find out if those processes are not being complied with? Can the compliance officer be able to tell you if they work within the PIC?
Yes, the compliance officer, to answer your second question first, the compliance officer must be able to report this mandate breaches or any breach of internal controls or processes that have been prescribed. And also, just to add on that, when we conducted the on-site visit, we did verify that the PIC had a proper governance framework in place. They had structures that supported that framework, and but some of the information that is coming out of here, tells you that what is on paper is actually not happening in reality or in practice. That's what we've observed.
Yes, because the worry could be that the compliance person there might be part of the management and not have the independence. Does that worry you?
We've considered that as well, and perhaps the independence of the compliance officer in this regard was compromised. And they're supposed to be reporting any irregularities to the FSP, whether one uses the services to the FSCA rather, whether one uses the services of an external or internal compliance services. Their independence mustn't be compromised. But it could be that it happened. I'm not saying it happened, it could be that it happened. Yes. And After the completion of the on-site visit, some allegations of irregularities concerning a loan by the PIC to Afrique Oil, Pty Ltd, appeared in the media. The media reports stated that the initial loan requests by Afrique Oil had been rejected by the PIC, but that the decision was subsequently reversed. And during the on-site visit, the FSB team was provided with a list of rejected deals, including loan applications. The loan application by Afrique Oil was not included in the list. The FSB therefore directed follow-up queries to the PIC on 15 June 2018. A response was received on 21 June 2018, and copies of the correspondence are attached to this. We do have copies of it.
The response to this query was signed by the then CEO, Dr. Machela,
Yes.
on the 22nd of June 2018, and this letter is attached to your presentation. Is that correct?
Yes, it is.
Now, were you satisfied with the response?
We were satisfied with the response because our focus when dealing with this query was on the actual or list of the rejected deals, and it concerned us that we're hearing about this deal in the media that does not even appear on that list. And the response, in terms of the response, Dr. Daniel Machila confirmed that the reports in the media are actually inaccurate. The deal went through the due diligence processes as prescribed through the different governance processes and structures. And at some point, there was additional information, required for the matter to be finalized, and they did exactly that. They obtained that information, and then the deal was subsequently approved.
If I can again ask you, in August, September last year, the PIC was also in the news regarding the CEO, the then CEO, Dr. Machela, an alleged transaction involving MST. Did it come to the notice of your organization? Did you investigate it?
Yes, we saw the media reports, and we did not investigate that particular transaction.
The other transaction in the news at the time was that of the VBS Bank.
Yes.
Did you do anything about that?
Yes, we investigated VBS Bank, and currently the matter is at finalization stages. And some of the people that are implicated in the VBS matter will, some of them may be debarred when we take appropriate regulatory action, and some of their licenses may actually be withdrawn as well.
Now, taking into account, as we all know by now, that the two employees of the PIC involved with VBS Bank, sitting on the board, were the chief risk officer and the head of legal. They are implicated and they sat on the board. Is that not a red light or a trigger for the FSCA to look at other issues at the PIC?
It is a trigger, you're right, because the two gentlemen that you're referring to have already been debarred from the financial services industry. And our investigations team is looking into this, and at the appropriate time, the necessary action will be taken in terms of how we need to proceed with this matter, who we're going to investigate, and the scope of the investigation.
Do I understand you correctly? Did I hear correctly that they've been debarred?
Yes.
From the FSCA?
They've been debarred from the financial services industry. Yes.
How did that happen?
The debarment was initiated by the PIC as the asset manager.
Thank you.
Thanks.
Question? What do you look at when you debar a person? What are the key issues that you look at?
We look at, the facts in front of us and whether the person, based on the complaints or the conduct of the person, whether they still meet the fit and proper requirements in respect of honesty and integrity. And what will happen is that we interrogate that information, and if there's sufficient evidence that points that the person does no longer meet the fit and proper requirements in respect of honesty and integrity, then that will result in a debarment. So the outcome of any investigation will inform that process, whether the person still needs to participate in the industry and the financial system or not.
And the integrity and the honesty, what will it mean? Will it mean what? Stealing money? What will it mean?
Yes,
what will
it's
it mean?
fraud, theft. If I may, I can also take you, if it's okay with you, Mr. Commissioner.
Yes, please.
That.
While you're doing that, if you could just perhaps add that if you're finding fraud, is it only applicable to the individuals involved, or how do you deal with the organization itself?
We look at the organization, the controls in the organization, processes, procedures, the governance structures, and we also look at the individuals implicated in that fraud. Honesty and integrity.
Can you just bear with us a moment, Mr. Commissioner?
They can check and come back to it. She can proceed, yeah. She can proceed.
Okay, thank you.
Yeah.
Okay.
Yeah.
All right. On 25th May 2017, the FSB received a letter from the Organization Undoing Tax Abuse Outer, dealing with the investment of funds by financial services providers into maladministered state-owned entities. Although not a specific complaint about the PIC, the letter demanded of the FSB registrar to, as a matter of agency, declare such investments in ESCOM by financial service providers, be they the PIC or any provider, public or private, to be undesirable practice in terms of Section 34 of the FACE Act. The FSB subsequently sought and obtained advice from senior counsel about the provision of Section 34 of the FACE Act within the ambit of the regulatory framework, and inter alia the requirement for FSPs to comply with the provisions of the Code of Conduct. The registrar decided not to declare investments in SOEs an undesirable practice. On 17 August 2018, a correspondence was received from Mr. Abraham Dubois, who essentially commented on the President's decision to establish a commission of inquiry into the PIC. The correspondence was not specific on any issue, and the request for additional information did not elicit such information. The FSCA was therefore unable to investigate the matter. Okay, Commissioner, if I may, can I take you through the incidents indicating when persons are not honest or lack integrity or good standing? Okay.
Just refer to the specific section in the Act.
It's Section 9 of the Determination of Fit and Proper Requirements. Without limiting the generality of Section 8.1 of the FACE Act, any of the following constitutes prima facie evidence that a person does not qualify in terms of Section 8.1 of the FACE Act. The person has been found guilty, and that conviction has not been expunged. in any criminal proceedings or liable in any civil proceedings by a court of law under any law in any jurisdiction, of an offense under a law relating to the regulation on supervision of a financial institution as defined in the Financial Institutions Protection of Funds Act 2001, or a corresponding offense under the law of a foreign country. Theft, fraud, forgery, uttering a forged document, perjury, or an offense involving dishonesty, breach of fiduciary duty, dishonorable or unprofessional conduct, or an offense under the Prevention of Corruption Act, the 1958, the Corruption Act 1992, or Parts 1 to 4, or Section 17, 20, or 21 of the Prevention and Combating of Corrupt Activities Act 2004, or a corresponding offense under the law of a foreign country. And the person has been convicted, and that conviction has not been expunged, of any other offense committed after the Constitution of the Republic of South Africa 1996 took effect, where the penalty imposed for those offenses was or may be imprisonment without the option of a fine or a significant fine. The person has accepted civil liability for or has been the subject of a civil judgment in respect of theft, fraud, forgery, uttering of forged documents, perjury, or any other conduct involving dishonesty, breach of fiduciary duty, misrepresentation, or negligent, dishonorable, and unprofessional conduct. The person has been subject of frequent or material preventative, remedial, or enforcement action by the registrar or regulatory authority. The person has been removed from an office of trust for theft, fraud, forgery, uttering of forged documents, misrepresentation, dishonesty, breach of fiduciary duty, or business conduct. The person has breached a fiduciary duty, or the person has been suspended, dismissed, or disqualified from acting as a director, managing executive, public officer, auditor, or statutory actuary under any law or any action to achieve one of the above-mentioned outcomes has been instituted against the person.
All right.
And is that sufficient? Okay. So that's my section 9 of the determination of fit and proper requirements.
Yeah, we can have a look at that one. Yeah.
Okay.
Thank you.
And the analysis undertaken by the FSB and FSCA of the statutory returns submitted by or concerning the PIC over the period in question did not reveal any material findings that caused the regulator to believe that the PIC is not, did not comply with all prescribed regulatory requirements. At the on-site visit of 6 February 2018, the PIC explained the procedures, the processes, and controls that are followed to make investment decisions and how mandate breaches are dealt with. And the on-site visit team was satisfied given the regulatory framework, which does not prescribe how a Category 2 FSP such as PIC should invest clients or the type of investments other than to comply with the required code of conduct. I trust that the information provided may be of assistance to the registrar and the FSCA and its personnel. We're here to provide any other assistance. Yeah, we're going to come back to this. I just want to get...
Are you ready for
Yeah, I just want to check with my colleague.
Is it not convenient to take the break now?
Perhaps it is, Mr. Commissioner, not to waste the time.
Yeah.
Can we have a 10, 15-minute
break.
break?
Yeah. Okay. Thank you.
We'll adjourn until 22:12.
Thank you, Mr. Commissioner. I think we are now in a position to provide the answers.
Thank you, Mr. Commissioner. You ask for the definition of the different financial products.
Is it listed somewhere in some piece of legislation, or?
It is listed in the Act, but they refer you to different acts as well, and some of the definition are not that clear. So we
Mr.
thought
Commissioner,
we'd
if I
paraphrase
can-
it, and yeah.
If I
Might
can
be
assist,
easier
the
for us.
definitions in the Act are very complicated and they refer to
Yeah,
other acts.
acts,
My request to the witness was to put it in just normal terms so that everybody can understand it.
Okay. Okay. If I may continue, I'll start with the definition of money market instruments. Those are those instruments that give the owner the unconditional right to receive a stated fixed sum of money on a specified date. And debentures and instruments, those are securitized debt, they are debt instruments rather. And a debenture is a debt instrument that accompanies the issue of shares in order to raise capital. Details of debentures are documented in an agreement entered into between the issuer of the debenture and the holder. And companies pay interest for the term of that debenture. And moving on to warrants. A warrant is a security that entitles the holder the right to buy the underlying stock of the issuing company at a fixed price called the exercise price until the expiry date of that warrant. And bonds. A bond is a fixed income instrument that represents a loan by an investor to the borrower. And this is a long-term investment, and the issuer of that bond will present the investor with a bond coupon, and the money will, at the end of the term of that investment, the investor will get their money back. And then the derivative instruments, those are financial securities whose value is reliant or dependent on the underlying asset. And lastly, you have your collective investment schemes. They're simply a unit trust. We used to call them unit trust investments. That is a scheme in pursuance of which members of the public are invited or permitted to invest money or assets in a pooled portfolio. And your defined the short-term and long-term deposit, deposits exceeding 12 months or less than 12 months, those are your bank deposits. So any advice or discretionary services relating to that simply refers to to those bank deposits, just your normal simple bank deposits. I hope that helps a bit. That gives more or less a sense. But we can later on provide the definitions. Those they are technical. We can also give you the relevant sections of the Act that deals with those definitions.
Okay, great stuff. Are you hip? Okay.
Mr. Commissioner, there's just one aspect I want to clarify. I think it's clear, but I just want to make sure it's clear. If there's a transgression of the license, let's talk about the PIC and the FSCA. The PIC can debar those people who transgress the license conditions, but the FSCA can also do that. But what is important in the case of the PIC, in terms of the Act, and I want to read it to the Commission, is the corporation must, in terms of the FICE Act, obtain authorization from the registrar as a financial service provider. But then Section 9.2 says the following: neither the registrar nor the corporation may terminate the authorization referred to in subsection 1 without the consent of the minister. I think that's important to note that.
So, meaning that the FSCA cannot unilaterally terminate the PIC's
Correct.
Yes, license.
Yes, thank you.
Just as a follow-up, maybe you want to take another bite on explaining the difference between advice, somebody can just give advice, and somebody can be an intermediary. And what do we mean by category 1 and 2, just for clarity for the House? Yeah.
Okay.
Yes. And sort of financial planners, where would they fit in there?
Yes.
Versus asset managers, can they do both, those kind of issues?
Your financial advisor, for example, will give you advice, and you also have, your brokers that will give you advice. And that simply refers to any recommendation. So the FSP, who's a financial advisor, would do a financial needs analysis to determine your financial needs and the appropriate and suitable products based on your on the outcome of the financial needs analysis. And they'll make recommendations and provide guidance or make proposals in respect of which financial products a client has to buy or a financial customer. And it's up to the client really to decide whether they want to accept that advice or not, because it's simply a recommendation. And when it comes to intermediary services,
would that person fall under what we call
Category 1?
Category 1.
Yes, FSP.
Okay.
Yes,
Okay.
yeah. And still on Category 1 FSPs, in respect of intermediary services, intermediary services means any act other than furnishing of advice performed by a person for, on behalf of a client or product supplier. The result of which is that a client may enter into, offers to enter into, or enters into any transaction in respect of a financial product with a product supplier, or with a view of buying or selling or otherwise dealing, managing or administering, keeping in custody financial assets. And in the context of PIC, this simply means that a client can approach PIC, an institutional client, and they can enter into a non-discretionary mandate with PIC, and that will fall under Category 1, and the PIC will always act on instructions of the client. So they will not have discretion in this regard. So they just accept instruction, then execute those instructions.
Yes. So meaning that before that financial planner buys a financial product, they will have to ask the client first. Is that
before, and actually the FSP in this particular regard cannot act without instructions from client, yes, because they have to execute the client's instructions.
That's all within the CAT 1?
There's the CAT 1, yes.
And CAT 2?
CAT 2, that's where the FSP has full discretion. They enter into a mandate with the client, and the mandate of the client will specify certain objectives, what they want to achieve, in monetary terms, maybe in 5 to 10 years' time. And, taking into account the objectives of the client, the asset manager would have to make decisions as to what the suitable financial products would be to place the client's money in, and manage that, to make sure that the clients get their returns.
Can one say CAT 2 will include advice section?
No, it does not include the advice section. The client, the asset manager has full discretion. So they don't have to consult the client about how or where they should be investing their money, as long as they make sure that they achieve the objectives of the clients and they deliver the returns on the investment.
And the PIC falls under what, Cat 2?
The PIC falls under Cat 2, though they have a Cat 1 license. They've entered into full discretionary mandates with all their clients, the 22 clients, yes.
So meaning you could have Cat 1 FSP doing the advice section, and then you could have somebody with Cat 2 doing the investment section.
Yes.
Is that correct? Is that
yeah,
correct?
and there's nothing wrong with an FSP doing both. You know, it depends on the structure and business model of the FSP. And sometimes it's safer to have the other categories just in case, you know, you have clients approaching you for advice only and not intermediary services. So a company can apply for Cat 1 without Cat 2, you know, or for both.
Thank you.
Thanks.
Can you tell us what your maximum sanction is to a financial service provider if there is fraud, material non-disclosure, apart from the question of disbarring?
The maximum sanction.
Yeah, maximum sanction. Should you have a financial service provider as an organization or entity, as well as individuals within that? What is your maximum sanction in terms of what law you can do?
Okay. Can I just consult my counsel on the monetary sanctions, and then I can speak to the other sanctions? Thank you, Mr. Commissioner. Okay, the sanctions, the maximum sanctions that we impose on financial services providers and you know, persons within those FSPs would be your debarment from industry, the withdrawal of licenses, and there will also impose penalties. But there is no limit on penalties. I guess the severity of the matter that you're dealing with will inform the quantum of that penalty.
When you say financial penalty, in criminal law terms would be fines?
Yes. Yes, it does, Commissioner.
You don't have prosecutorial reference. You would have to refer prosecutorial matters to the relevant entities responsible for prosecution or investigation for prosecution?
Yes, we have to refer that to the prosecutorial authorities for assistance.
Two more questions. In terms of the number of the FSPs that you sort of regulate, just give us a sense of the number. I understand it runs into thousands and thousands. Just give us a sense.
That's correct. We regulate almost 11,500 FSPs. Yes.
And do you find that you got enough manpower, person power to regulate those?
There will never be enough manpower to regulate all FSPs. That's why we have a risk-based, we follow a risk-based approach when supervising these FSPs. You know, this approach actually assists us as a regulator to assess, you know, the level of risk in the operations of different financial institutions, and collect data from those assessments, including data relating to complaints, or data, you know, from the that we extract from the analysis of statutory returns, and that actually gives you an idea. You are in a position to identify areas of concern and risk areas, and you know, the process helps you actually to allocate your resources, the very limited resources that you have, to those areas you deem to be posing the greatest risks to clients, and also make sure that the resources that you currently have, place more time and effort on the supervision of those entities.
And are you happy with the budget and the staff complement generally at the FSCA?
We are currently in the process of recruiting for more staff because, we have an extended mandate now that will include the provisions of credit and payment services, and this is something that we've not done before. And we're also capacitating the authority with research capabilities. So we have to get more people. There's a dedicated division or department in the regulatory policy division that will look at that, and we have to get more staff. So it would be nice if we can get one person to look after one FSP, and then that means that we'll have 12,000 employees, but we cannot afford that. Yeah.
And then the final question is a broad one. During the, people have come here to talk, and we have noted that there are professionals that have been forced to do things that they don't want to do, or it's against the processes or against the laws and all that. And sometimes they cannot say no because they're scared that they will be fired or victimized and all that. Is there a way in which FIS or the FSCA can assist the employees that are under pressure from bosses to, in terms of doing wrong things? I mean, you got chartered accountants who can get their, accreditation removed, and you can be debarred and all that. Is there a way in which the FSCA actually can help there?
Yes, actually, in terms, I'll get the necessary section in the FSR Act where any person can report any irregularity to the FSPs without, disclosing such. Obviously, they won't disclose it to their employers, but the information will be safe with the FSP. Your whistleblowing services, we've got that, where people report irregularities all the time, and we take action against those individuals.
And it does help? I mean, have you found it helps that...
it does help because some of the information they trigger, we've done lots of on-site visits that were informed by whistleblowers, and or some reports that were, or information that was reported to the authority anonymously. So it has helped previously.
If you have somebody who has been debarred from, or his or her license taken away, is that usually for good, or do they rehabilitate themselves and make a comeback?
They do rehabilitate themselves, they do make a comeback, but also even that, that does not mean that we'll just accept them into the financial services because their term of debarment was 10 years and it has expired. We don't do that. We still interrogate their applications, and we still look at the extent of, their irregularities or any conduct that they've been engaged in previously that led to the debarment. Because we have to test whether the person has indeed been rehabilitated before you accept them back into the financial system.
If you look at page 8 of this document that you took us through, it's not signed by you, is it?
No, it's not signed by me. It's signed by the Commissioner, Mr. Abel Sithole.
Is it Mr. Stole's signature? Is that Mr. Stole's
That was signed on his behalf by Mr. Dube Chidi.
By who?
Mr. Dube Chidi. He's part of the Transitional Management Committee and the former CEO of the Financial Services Board.
All right, but you yourself have knowledge of what you have gone through with us? to this document?
I do have knowledge of the content of the document, Commissioner.
Yes, thank you.
Mr. Commissioner, before we finished, I was requested by Mrs. Tsombe, the head legal, to just make another addition to the question raised by Ms. Marcus about Mr. Sithole. With your leave, can she just put it on record?
Thank you. Thank you, Mr. Commissioner. This is just to ensure that I put the position of the principal officer of the GEPF accurately. What the principal officer's responsibility is in terms of the board and in the meetings of the board is that he ensures that the board meets its fiduciary and oversight obligations in terms of the GP law and other regulations that are applicable. It also, the PO also assists the board on a policy level where policy discussions, for instance, the board generally gets represented by the PO sometimes in parliamentary discussions and also at national treasury level. He also ensures that the financial responsibilities which are about reporting and disclosure, consolidation and amending the fund's rules, and also evaluating the liabilities of the fund. He is responsible for all of that. He implements the board's decisions, ensures that the board's strategy is implemented, and he is obviously assisted and supported by an executive team within the GEPF. I just wanted to put that into proper perspective.
But does the GEPF not have its own CEO?
No, Chairperson. It's I would say the board. If I start with the board has got a chairperson, and then the GEPF has got the principal officer, and not a chief executive.
So to add is that generally pension funds don't have CEOs, they got POs, isn't it?
Yes, that's in fact, even in terms of the Pension Funds Act, pension funds have got principal officers as opposed to CEOs.
But just one clarity in terms of accountability, where the buck stops. If there's an issue with the GEPF, is it the chairperson of the board who is accountable for the operational functioning of the GEPF in all its entities, or is it the principal officer?
I am not sure, but I would, if I were to express an opinion, I would think that it is the principal officer that reports to the board. But at the end of the day, the ultimate responsibility for the fund lies with the board, and therefore with the chairperson of the board. The principal officer assists the board.
Mr. Commissioner, we undertake to clarify that and place it in proper context before the Commission. Can I ask for a brief adjournment? The next witness is available and ready. He will be presented by my colleague, Mr. Monahela. 3 or 4 minutes just to rearrange the scenery will suffice.
We'll adjourn until you call us.
Thank you, Mr. Commissioner. Our next witness is Mr. Sunil Verghese. He's ready to take the oath.
Can you pronounce your surname for me?
Verghese.
Verghese.
Yes.
Aha. You don't have any objection to taking the prescribed oath?
No, Commissioner.
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? So help me God.
So help me God.
Thank you. You may be seated.
Thank you, Commissioner. May I just ask to be seated while leading the witness?
Though you are young, you can be seated.
Mr. Verghese, you've made a statement which you're about to present to the Commission. Could you please start at paragraph 1 of your statement?
I'm an adult male currently employed by the Public Investment Corporation, PIC, as a portfolio manager, non-consumer industrial, listed in the listed equities division. Save where the context indicates to the contrary or where it is otherwise stated, the facts contained in this statement are within my personal knowledge and are, to the best of my belief, both true and correct. I have, to a limited extent, been following the statements made by the witnesses who have given evidence to this commission, as well as following some of the media coverage from various media outlets. In this statement, I respond to allegations that Mr. Siani has made directly against me in his statement or in his testimony. Where I have failed to respond to any particular allegation that refers to me or that affects me or my rights, I reserve the right to respond to that particular allegation. To the extent that any such allegations are inconsistent with what is set out in this statement, I deny those allegations. Commissioner, may I pause here to say, ordinarily, I would not make statements against others. I do not have anything personal against Mr. Siani, who I hold in the highest regard. But given that he has made certain statements against me, I just want to clarify in the later part of my statement.
I'm just wondering how to interpret what you say in reserving your rights.
Yes, sir.
You say, I reserve the right to respond to that particular allegation. Do you see that? I'm just wondering whether it means you'll call us back and say, hey, I want to respond to that. Come and sit.
No, I said, well, I have failed to respond. I reserve the right in future if somebody tells that. That's all I'm saying.
Yes, that's what I'm saying.
Yes.
How are you going to get here to exercise that right?
Commissioner, I would probably go through them.
I think I'm being facetious. Yeah. Okay.
Yeah. Okay.
Commissioner, may I just ask him this question? Is there any particular allegation that was made against you that you did not or have not addressed in your statement?
Not to my knowledge, Commissioner.
That answers it.
Yeah. May I continue? My education and background. I have a Bachelor of Commerce degree from the University of Botswana, where I was a top student. I'm also a fellow of the Chartered Association of Certified Accountants in the UK and an associate of the Chartered Institute of Management Accountants in the UK, and also a Chartered Global Management Accountant. I have an MBA from the Edinburgh Business School, which is part of the Heriot-Watt University, and completed a certificate in portfolio management from the New York Institute of Finance. I served my articles with a small accounting firm in the City of London, largely involved in audits. Upon arrival in South Africa in 1992, I joined Pricewaterhouse as a senior corporate tax consultant dealing with large corporates. Subsequently, I moved on to the management consulting division and later to the value-based management division, where I was primarily involved with the valuation of companies. I joined the financial markets in 1998 as Vice President of Research at Deutsche Morgan Grenfell, which later became Deutsche Bank. Here I was responsible for sell-side research in the telecommunications, utilities, and industrial sectors. I subsequently left for HSBC in 2003, where I was a senior investment analyst until 2005, covering industrial companies and oil and gas sectors. I was top-rated in the telecommunications and industrial sectors in the Financial Mail and Reuters service from 2000 to 2005. I was responsible for conducting investment research and marketing to institutional investors across South Africa, Europe, Asia, and the US. These include OMAM, SIM, Coronation, Fidelity, Templeton, Prudential, Alliance Capital, Wellington, Capital Research, Goldman Sachs Asset Management, Stanlib, JP Morgan Asset Management, Schroders, Allen Gray, and RMB Asset Management. In 2006, I joined the PIC as an investment analyst and was promoted to the position of portfolio manager in 2008. Over this period, I have largely covered industrial companies and am currently responsible for the non-consumer industrials portfolio. My sector experience includes telecommunications.
Sorry, can you enlighten me about non-consumer industrials?
Yes, so the JSC is classified into various sectors. So you have the resources, the financials, and the industrials. Now, industrials is a broad statement, so we split it into two sectors. One is which is mostly consumer facing, and other which is non-consumer facing. So these could be manufacturing. Well, to be specific, what falls within non-consumer space is healthcare at the moment, TMT, then there's building and construction, transportation, and diversified industrials in the broader sense. Thank you, Commissioner. Point 5.6, I'm also a licensed lay minister of the Anglican Church. Now, I go to the internal listed equities division. This division manages a portfolio of stocks that are listed on the Johannesburg Stock Exchange and other exchanges in Africa. At 31st January 2019, the value of the equities managed in-house was approximately 700 billion. Of this, approximately 475 billion is a pure index tracker fund managed by the quants and derivatives team, and the balance of approximately 225 billion is an enhanced indexation fund. Our clients prescribe the benchmark index that is tracked or enhanced. This would be broadly, this would be the all SWIX adjusted index. So we strip out things like gambling stocks, etc., but the client tells us how our benchmark should look like. May I pause there and make a comment? You know, this is a very large portfolio. The equities portfolio, which is under the PIC, is about R1 trillion. Or on average, we own, say, roughly 11 to 12% of most companies on the exchange. So we are a significant player. And we are the largest asset manager in Africa. I mean, if I had to use an analogy of boxing, we would be heavyweight, or if there was a classification called super heavyweight, that's why we would be punching. Okay, so it's a big asset manager, and there are pluses and minuses of that. Being so big, if you start selling a large quantity or buying a large quantity, you have market impact. So we are constrained due to our size. So I wanted to put that in perspective. The enhanced.
Sorry. Can I just ask a question in relation to that? Because I can see, obviously, the PIC can impact the market in all of its decisions.
Yes, Commissioner.
It can do that. Does it not have a different implication as well, that because you deal with such big amounts, that billions are actually small to you and are small change, and therefore you can become careless with the billions?
I think, yes, in the materiality context, yes, the numbers might look small, but we take care of whatever decisions we do. I mean, we have a process which we will go through. I think my colleague and my boss, Lebohang Malabat, touched on it. So we will go through that, the research and how we implement the monies into the portfolio.
Yeah, I'm raising the question because obviously from the evidence that has been coming before us, there have been questions about, you know, because of non-materiality in the overall does not make a billion small. And I would be a bit concerned about the way billions, individual billions per billions have been spent or allocated. So
well,
I appreciate the process, but what we're seeing in evidence before us is flaws in the process.
Commissioner, I can only speak for myself, and I believe that is the view of the rest of the listed equities team as well. You know, we are quite aware that it's hard-earned pensioners' money, and we don't take that lightly. And myself, being the son of a teacher who used to contribute to this fund, I'm well aware who we are working for. Yeah. Point 6.2, the enhanced index funds makes tactical decisions to deviate from the benchmark, where the team is of the opinion that a stock is expensive or cheap. I'm a member of the enhanced indexation team, which is headed by a general manager, Mr. Lebohang Olabatsi, who is my line manager. He reports to the executive head listed investments, Mr. Fidelis Madavo. The portfolio is divided into 4 sector teams, namely resources, financials, consumer industrials, and non-consumer industrials. In addition, a separate team looks at listed properties. The organogram also makes provision for a listed Africa portfolio. Each sector team is divided into 3 individuals made up of a portfolio manager, assistant portfolio manager, and an analyst. The listed equity team is made up of, I think there was a typo there, so it should read as approximately 20 individuals with varied levels of financial markets or industry experience, and include CFA charter holders, chartered accountants, engineers, MBAs, graduates, and postgraduates. The non-consumer industrial listed equities team is made up of me, Mr. Victor Siani, who is the assistant portfolio manager, and Mr. Desmond Sibui, the analyst. The internally managed listed equity composite portfolio has beaten the client benchmark by 213 basis points over 3 years and 131 basis points over 5 years for the period to 31st January 2019, according to our internal calculations. We have a separate performance and attribution division who gives us these numbers. The fee structure is low at 3 basis points on listed equities, which if I compare to the private sector, you know, it could be 10 times and higher than what we charge.
Question?
Yes,
Yes,
Commissioner.
Mr. Vagiz,
Yes.
it's been a long time, eh?
Yes.
It's been a long time.
Yes, Chief.
Since we last met. Yeah, I just want to double check point 7.
Yes,
Point
sir.
7. If you could give me roughly your broad performance, you know, which includes fixed income, money market, you know, for one particular client over the past couple of years. Can you give us that, say the GPF?
Commissioner,
I know Lebohang did speak a bit about it, but yeah.
Commissioner, I don't have it handy at the moment. Can I pass it through the evidence leaders? Okay. And I think if you look at our annual report, which is obviously a bit stale at the moment because a few months old, it does make it clear the performance of all categories there.
Thanks.
Commissioner, if I may pause and comment on this performance. In our view, this is an excellent result. So in other words, we are proxy for the market and we are actually competing against ourselves. With a tracking with a tracking error budget of 1.5% given by the client and a return of 213 basis points, that would, what we call in our industry, there's an information ratio, which is active returns divided by active risk. That gives to 1.42. Anything over 0.5 is considered good to excellent. So I think we've done well. And if I may pause to lighten the mood slightly and use the boxing analogy again and borrow a quotation from Muhammad Ali, I think we have earned the right to say, we float like a butterfly and sting like a bee. Thank you for that.
Can I just ask you to say it again, those performance figures, please?
Yes.
Please. Yeah.
213 basis points over 3 years and 131 basis points over 5 years.
The outperformance.
Outperformance, yes. It's the outperformance. Point 8, the research process. PIC follows a 4-factor approach when analyzing stocks: competitive advantage and quality, ESG and stewardship, valuation, and uncertainty, rating, and risk. This process was introduced to our team by Mr. Lebahang Malabatsi, who made his statement last week to yourselves. Now let's unpack the 4 factors. Competitive advantage and quality. They use the Porter's 5 forces framework to determine the competitive advantage and quality of a company. That broadly looks at the strength of the customer, the strength of the supplier, industry, rivalry, barriers to entry, etc. So that is the Porter's 5 forces framework. The ESG and stewardship. Good corporate governance and adherence to best practices on ESG leads to sustainable returns. We use the reports and scoring done by the ESG team in our analysis and engagement with the board and management of companies to ensure that best practices are adhered to and influence our thinking in proxy votes. Valuation. Our key assumption is that fundamental fair value is discoverable. So the tools that we use include DCF, IRR, exit PE, price to book, and EV to EBITDA, amongst others. Uncertainty, rating, and risk. This is a measure of how uncertain an analyst is on his or her fair value call, using operating leverage and financial leverage into consideration. Now we go through the various decision-making structures that we have within the team and in the broader church. Morning meetings. These meetings occur on a weekly basis and are used to track market developments, including results and economic data releases. They are used as red flag generators in that any information that may impact the house view is highlighted at this level for a detailed analysis to follow. Then we have the deep dive research meetings. Once detailed analysis on a stock is done, then a deep dive research document is presented to the team using the 4-factor analysis framework. The merits of the document are debated by the team and a stock call is agreed upon. The research report is then loaded onto the code red system. Periodically, updates on the stock are presented when the analyst view has changed on the company or when results are announced. If I may pause there, the code red system is available to the decision makers within the PIC at any time. They can pull a stock, see the PIC's view on it, what is the upside, downside, there's a ranking table, etc. in there.
Question? Question. If you have a deep dive report on Steinhoff and the unlisted site is doing a transaction, will they have access to that report, or it's a separate department and all that?
Yes. Commissioner, the way these Chinese walls work, including from when the days of, including my days at investment banks, the other side of the Chinese wall, meaning the unlisted or in investment banks, is corporate finance. They can have access any time into our work, but not the other way around. Yeah.
And it's like it's done the same way within the PIC?
Yes, Commissioner.
So they cannot look the
other
guys that can be the other.
Let me quote the Steinhoff example. Until we are made insiders, and if we are made insiders, we embargo the stock. So until we are made insiders, we will have no clue what the unlisted team would be doing. Sector focus meetings. These meetings are held periodically to discuss the overall sector views. Portfolio manager meetings. These are held on an ongoing basis, if possible weekly, to ensure that the portfolio reflects the views of the team and risk budgets are within the parameters set by the client. Portfolio management committee listed. So now we are entering the broader church. The other 3 meetings were within the team. This committee is the oversight body for listed investments, and members are executive staff of the PIC. The chairman of the committee is the CEO. This committee approves deals that are between 3 billion rand and 10 billion rand.
Question? Yeah, a question.
Yes, Commissioner.
If you could explain a bit what the risk budget is.
Oh, risk budget.
Yes, on 9.4 you talk about the risk budgets.
Yes. So, let me give you a mental picture of an index, which is the benchmark, right? So, in the instance of GPF, which is our largest client, they say any deviation from the benchmark, when you sum it all up, because sometimes you stray from the benchmark, say 0.3%, some you take 2 to 4%, but when you average it all out, the deviation from the benchmark or your bet size should not be more than 1.5%. So that is the risk budget. So in simplistic terms, let's say Naspers or Anglo-American, let's take Naspers. It's almost 25% of the benchmark. So we can deviate from the benchmark if we are positive on the company. Say I can take 27% of my fund into Naspers as opposed to 25% in the benchmark. Or if we are negative about the company, we would go minus, not minus, 24%, which is a minus 1% to the 25% in the index. So, but the key number is that when you sum it all up, it should not exceed the client prescribed deviation from the benchmark, the tracking error. And the client specifies if due to market movements, you have breached this, then you must report to us and rectify it ASAP.
So meaning that there are some positions you can take that are not beyond certain limits and all that. Is that what you're saying?
Yes.
In various stocks?
Yes. So if I could clarify again, although it's 1.5% at the aggregate level on individual, you could go to 3 to 4% if you want, but because the other ones are taking very small bets, it cancels it out, and on average you end up at 1.5%. So I think we have dealt with the PMC. The next one on 9.6 is the investment committee. This is the board delegated committee that has an oversight function of the entire investments managed by the PIC. The membership is made of non-executive directors and executives of the PIC. The chairman is a non-executive director. This committee approves deals that are above 10 billion rand or smaller deals if they have been referred to that committee by the PMC. Initial public offering, or the IPO process. IPOs do not occur on a regular basis. Ordinarily, only a handful of IPOs happen in a given year. All specific deals such as IPOs, BE funding, or taking up strategic stakes should be accompanied by an origination report with our initial analysis and view of the event that requests permission from PMC listed committee to do a due diligence along with legal risk and ESG department. This is commonly referred to as the PMC1. At that point, the legal risk and ESG departments are engaged, and a due diligence process is undertaken along with the equities department.
Question, sorry. Yeah. Would BE funding fall under listed in strategic stakes? What would those be?
Commissioner, it can be in listed or unlisted, right? That's BE means what percentage of the company is held by, previously disadvantaged communities. So my answer to that, it could be in either space.
What, meaning that that you would be taking a stake brought by a BE company, how would it arise in the listed space?
In the listed space, there could be two opportunities. There could be more, but that's two that I am aware of. One, it's an initiative where a bunch of potential BEE, candidates come to the PIC and say, this is a company that is already listed on the JSE. As far as we're concerned, it's not transformed. We've got the funding, etc. Would you support us? So that is one way. The other one is when the company itself does a BEE deal and comes to us. So I could quote one which is work in progress at the moment, which is the Bala World one. They're doing one at a BEE deal at the moment. And they use their external advisors, they met their committees, etc. And now they're coming to the market to inform us of the BEE deal.
And that transaction wouldn't go to the unlisted PMC and all that. It will go to the listed PMC.
In my understanding, it would go to the unlisted if unlisted finances that consortium. Yeah. Because sometimes the banks are reluctant to finance, and then PIC makes its own decision on the unlisted side. I don't know how they operate, but I'm aware that they have funded certain BEE deals.
What are strategic stakes? The IPOs we know now.
Yes, as strategic stakes, as far as the GPF mandate says, they will let us know what is strategic to them in the interest of the country. So they will let us know, and we will follow their mandate.
Give an example, say one example. What would it be?
And I cannot name a company per se, but let's say there's a flagship South African company that has been built over hundreds of years or 50 years or whatever. So I can talk about a transaction that already has happened and it's gone. But SAB Miller, it's a South African born, South African raised, quite successful across the globe. And now there is a hostile takeover attempt by AB InBev. Now, the client could have had the view that, this could lead to so many job losses, etc. And it's a flagship of the South African economy. We don't want it to be owned by foreigners, etc. I don't know what criteria they use. And that could be classified as a strategic investment.
Yeah, I get you, because there was the one issue about Anglo selling stakes in SA, and I think there was an issue about the establishment of a black bank also. Would those be part of the,
I think
of the issues?
Those are along the lines that we are discussing about. Thank you, Commissioner. 10.3. After the due diligence has been completed, a final PMC submission should be made after the document has been provided for submission by the executive head of listed investments. This is then prepared to a follow-up meeting of the PMC listed committee to approve or reject the deal, and this is called PMC 2. I pause to note that there is segregation of duties between the different teams that submit a report for approval: the PMC, investment administration team, who are the back office, and finance team, who disburses the funds post-approval. Once a deal is approved by the PMC or IC, the finance team needs to receive a payment memo that is certified by the legal team to ensure that all conditions precedent have been met. Confirmation by the CFO that funds are available, and approval by the CEO to proceed with the payment. This ordinarily is also accompanied by a copy of the resolution approving the deal by the PMC or IC. So finance can check that this has already been approved by the PMC. The IO transaction. The IO transaction leading up to the PMC meeting of the 20th of December 2017. I start off by giving just a background of the company, and then we'll go into the details. IO is an empowered ICT group. ICT meaning information communication technology, offering numerous end-to-end solutions to a host of industries. IO was established in 1996 and has evolved over this time through continually adapting to the local and international ICT landscape. The process of adaptation was enabled by acquiring new businesses, partnerships, and sourcing innovative technology within its existing portfolio. The AEEI Group, which is the holding company of IO, had a 30% stake in British Telecom South Africa, and upon IO's listing, it was to be transferred to IO. Through its superior empowerment credentials and strategic alliance with BT, IO recognized a clear opportunity to aggressively grow its business in order to continue to increase shareholder value and drive true transformation in the South African and African ICT markets sector. Commissioner, may I pause here and say, I will give you the events that led up to the 20th. Then there's a section later where I touch on the investment case and our valuation. So I'll discuss those matters when I get to that stage, with your permission.
And perhaps in that, if you could identify where in the timeline you became aware that the BT transaction was not part of, or was not going to happen.
Yes, I can tell you already.
Okay.
Commissioner, our our mindset or our thought process at the time when we did this deal was that the BT transaction was a sure thing. Because the associate company or the affiliate company rather, AEEI, already owned a 30% stake. They wanted to move it to the IO stable, and then BT also would be happy to be empowered, and using those two, or using that combination, they were the vision was to have a proper BEE ICT company that could challenge the likes of the already listed peers, like EOH, Adapt IT, etc. So that was our thought process at that point in time. When did we get...
Can I just ask you on that?
Yes.
As you elaborate,
yes.
Not necessarily now, is that would you have had a different view of the transaction if you'd known that the BT was not part of it?
I think, Commissioner, I might have had a different view, but remember BT was a cornerstone of this investment, and unless they brought something else, but that was not in the PLS. I touch on what they disclosed in the PLS, what was our thought process, etc. Can we discuss that when we get there, with your permission? So, now here's a nuance that I would like to introduce. I think Mr. Mulabatsi touched on it. I just want to expand on it. So, if you took a step back, what was going to be their business model? This IO. It was going to be a BE company that was going to raise funds in the market and deploy those funds to buy BT, and they listed about 10 other companies. So in our view, although in the strict interpretation, as the law states, it's not a special purpose acquisition company, it displayed all the characteristics of a special purpose acquisition company that raises funds in the market to acquire businesses to fuel growth. On the 15th of November 2017, Mr. Madao received an email from the executive assistant to the AEEI CEO asking him to sign the attached NDA, which would be collected on the 16th of November 2017 when he meets him in person. Then on the 16th of November 2017, Mr. Victor Siani, the APM of Non-Consumer Industrials, and Mr. Desmond Sibui, who is the analyst, held their first meeting with the AEEI Head of Corporate Finance, Mr. Abdul Malik Salih, Mr. Kevin Hardy, who was the CEO, Mr. Simpiwe Nodwele, CIO, and two others on the instruction of Mr. Madao. The purpose of the meeting was for the AEEI to present an investment opportunity in the upcoming IPO of IO Technology Solutions Limited. Usually such meetings are meant to gauge the appetite of the PIC to participate in the IPO. Upon returning from the meeting, Mr. Siani came and briefed me. He actually dropped a copy of the presentation on my table, and we had a brief chat on it. I was unable to attend as I was tied up with other work and could not attend the meeting. On the 17th of November 2017, Mr. Salih sent a non-disclosure agreement, an NDA, for PIC to sign. PIC returned the signed NDA to Mr. Salih, who became the PIC's main contact for information on IO. Mr. Siani at that point became the primary contact at the PIC for IO. Mr. Siani also asked Mr. Salih to send the main listing documents and historic financials for at least 3 years on entities that will be acquired by IO. I paused to note that Mr. Siani was working closely with the PIC CEO's office on this transaction, and I was filled in on a need-to-know basis. I think the evidence team can look at the emails and testify to that. On the 24th of November 2017.
Question? Yeah. On your last note today, that is it sort of regular that the assistant portfolio manager like Mr. Siani can work directly with the CEO or the ex-CEO?
I think he was briefed in the sense that if the CEO calls you to his office, you can't say you can't go, right? So I think he went there and he got updated on a regular basis. And I think it is not normal, but it happened. And it's a statement of fact than just a mere statement. So I just want to put it in the commission, so to give you a broad...
Sure.
Yeah.
Just to double check the structure and the culture at the PIC. So the heads can go above the line managers and all that and just say, we are zooming in on the assistant portfolio manager. Is that how it's done? I mean, normally at the PIC?
I wouldn't say so, but I suppose in the ex-CEO's words, he had an open door policy, so people were invited to walk in and explain to him what is happening, etc. So I don't know what happened, but that is my assumption, sir. On the 24th of November 2017, Mr. Sally sent the requested financials, except BT financial statements, to Mr. Siani. Mr. Siani started working on the pre-due diligence request analysis and requested documents on IO. I'll touch on that a bit later. Mr. Siani, between the 27th to the 30th of November 2017, Mr. Siani contacted the ESG, legal and risk teams to inform them of a pending IPO of IO and send them the draft documents received from AEEI and requested them to start working on the due diligence documents in the interest of time. I point out that neither I, nor to the best of my knowledge, Mr. Malabatsi, were copied in on this communication. We were not aware of the steps that Mr. Siani had taken to secure the due diligence. I only discovered this fact after we started gathering evidence for the commission and going through printed copies of his emails. On the 4th of December 2017, Mr. Siani emailed a list of 36 due diligence questions to Mr. Sally. On the 5th of December 2017, Mr. Siani sent the request for due diligence documents for review by Mr. Malabatsi and myself for submission to a PMC meeting of the 6th of December 2017 to seek permission to conduct the due diligence. This document included an investment case, valuation, and recommendation that Mr. Siani prepared using the draft listing statement and other financial information provided to him by AEEI. Mr. Malabatsi was in Cape Town and refused to review it since he received it at the last minute. Consequently, the PMC1 meeting of the 6th of December 2017 was postponed. I would kindly request you to note the intention to follow process of PMC1 at that date. On 7th of December 2017, AEEI sent the responses to the 36 questions asked by Mr. Siani and informed him that all forecasts are organic and do not include acquisitive growth. They also mentioned that BT has international policies around confidentiality, so they cannot send the audited financials. However, the extracts of the BT financials were included in the pre-listing statements, which have been reviewed by the reporting accountants.
Just at this point, this response reconfirms the involvement that BT was part of the deal.
Yes, and it was in the Commissioner. If you go through the PLS, which is released by, it is there. They said pro forma with BT and without BT and with other acquisitions. And then they had 4 or 5 years of the, what can I say, the pre-existing IO business before they would deploy this money and add onto that.
Can you recall what value was the BT? What valuation was put on BT?
By the reporting accountant?
No, by IO. You know, they were trying to purchase a stake from a BT stake. Can you recall what valuation IO had put on BT?
Commissioner, I cannot respond to that at this point in time, by what value they purchased. But I think if I again go through the statement by Mr. Siani, he indicated that they were going to deploy about R1 billion or something for the BT acquisition.
1 billion rand?
Yes,
Okay.
yes. On the 8th of December 2017, Mr. Siani approached me and we discussed whether it was realistically possible for the PIC to meet the IPO date of 15th of December 2017. We both agreed that it was not realistically possible. Mr. Siani further discussed this with Mr. Malabatsi and accordingly notified Mr. Sally that the earliest that PIC could make a decision on the IPO is near the end of January 2018. He informed IO that the PIC view is that the 15th of December 2017 deadline is not realistic. On the 13th of December 2017, private placement was open to the public and would close on the 15th of December 2017. The finalized PLS was also released. The document requesting PMC to approve a due diligence was signed by Mr. Siani, Mr. Labahang, Malabatsi, and me. We signed this document because we were instructed by the PIC CEO, Dr. Majila, that the IPO would not be moved, and therefore the DD had to be completed urgently. The PMC meeting to request approval for due diligence was scheduled for 3 p.m. to 5 p.m., but the meeting was cancelled as it was not correct. Note again our second attempt to follow process on PMC 1. On the 14th of December 2017, at 8:30 a.m., Mr. Malabatsi informed Mr. Siani that he had received instruction from the CEO, Dr. Majila or Dr. Dan, to participate in the IPO. Subsequently, Mr. Siani and I were notified by Mr. Malabatsi that Dr. Dan has instructed the team to have the PMC2 document, which is the post-due diligence appraisal document, ready for a round-robin approval by the close of business on that day. Dr. Dan told Mr. Malabatsi that the failure to obtain PMC1 approval would be ratified by the PMC and that we did not have to be concerned about this. You will note that this was ratified accordingly by the PMC on 20th December 2017. At 9:50 a.m., Mr. Siani gave a heads up to our back office or investment administration division, who are responsible for the processing of payments and capturing all the data into our systems, that the PIC is going to participate in the IO private placement. And at 9:54 a.m., he alerted our advisory teams, the ESG, legal, and risk teams, that they should submit their PMC2 document ASAP for a round-robin resolution that would take place on the 15th of December 2017. At 11:03 a.m., the subscription form signed by Mr. Malabatsi, PP for Mr. Fidelis Madao, was sent to Dr. Dan for his signature. At around 11:30 a.m., a corrected subscription form was signed by Mr. Malabatsi, again PP for Mr. Madao and Dr. Majila for 4.3 billion rand. Upon hearing this, I went to Mr. Malabatsi's office and expressed my disappointment and frustration with the CEO's action that he had signed a subscription form ahead of the PMC2 approval. And Mr. Malabatsi shared my sentiment. This was the first time I had ever seen anything like this in my career at the PIC. At 12:03 p.m., the signed subscription form was sent by Mr. Siani to the Investment Administration Division. At 4:27 p.m., Mr. Siani left a signed PMC2 submission on my desk and asked me to review and get Mr. Malabatsi's approval. Mr. Malabatsi and I signed it after reviewing. For all intents and purposes, this was an identical document to the one sent to the company secretariat seeking permission to do DD on the 13th of December, or to the document he prepared for the 5th of December, except for the amount of 4.3 billion that was going to be subscribed. PIC's ESG team submitted its completed ESG due diligence report on IO after studying the PLS. Again, all these statements are for the 14th of December. I would request the Commission to kindly note that I signed off from the PIC on that day for annual leave with the knowledge that an appraisal report was prepared by Mr. Siani, reviewed by myself, recommended and approved for submission to PMC by Mr. Malabatsi for the committee's consideration by round-robin resolution on the 15th of December 2017, where the approval would be dependent on the merits of submissions of the listed equities, ESG, risk and legal departments, after these had been studied by the members of the committee. So, if I may pause here, I left on the impression that a round robin would happen on the 15th and they would make a decision prior to the close of the deadline to submit subscription forms. This 14th of December 2017 was the last working day for the year for me. From the 15th of December 2017 to the 1st of January 2018, I was on annual leave and left to India to see family. Over this period, I did not receive any communication on the deal, except for the 20th of December 2017, when Mr. Siani asked me if I should be allocated to a strategic fund, and I replied in the affirmative.
Would this be a convenient place to adjourn for lunch?
Mr. Commissioner, can you just proceed until paragraph 11.24, which is on the next page?
Okay. Now I'm going to state some points for events that happened between the 15th of December 2017 to the 31st of December 2017. These are based on documented evidence in our position, given that I was away from the PIC at that point in time.
Just a quick check. So by the time you went on leave, you were aware that this transaction is a done deal, really, in many ways, because the subscription form was signed.
Subscription form was signed, but if the PIC overruled it, they could advise the custodians or whoever processes these things to say, hold on, don't release it to the counterparty until we've made the final decision. Because we sometimes do it sometimes we send these forms, a proxy vote or something like that, ahead of a certain decision. But we say, we just adhering to timetable, but please don't forward it on until we give you the final go. So on the 15th of December 2017, PIC's legal team submitted its completed legal due diligence report on IO. PIC risk team submitted its completed risk due diligence report on IO. Both reports were compiled after studying the PLS. So in other words, what I'm trying to say there is all 4 reports were submitted ahead of the PMC meeting. A request to waive PMC 1, the approval to due diligence due to the fact that due diligence had been performed was approved for submission to PMC. Round-robin request for approval was sent to PMC members by email from company secretariat. Also copied were head of internal audit, Head of Investment Management, Head of Corporate Affairs, Company Secretariat, and Mr. Siani. They did not complete the round-robin resolution on that day, perhaps due to lack of responses from the PMC members. Remember, it's the eve of the week before Christmas, so probably they left. On the 18th of December 2017, IO Technologies put out a SENS announcement that it had received applications for subscriptions for 5.3 billion rand. In other words, an oversubscription of rand 1 billion to the size of the private placement.
Do you know if that was accurate, given that in the end the only uptake was by the PIC for 4.3 billion? So what happened to the other billion?
Yeah, Commissioner, I am also asking the same question. Why didn't they give us a pro rata? You know, so that the question remains unanswered at this point in time. On the 19th of December 2017, Dr. Majila sent an instruction to the Acting General Manager, Mrs. Haniwe Adams, to proceed with the payment settlement process. Dr. Majila stated that the PMC will be asked to ratify the payment. The payment memo was signed, noting that the transaction will be ratified at the next PMC meeting. Investment Administration Division sent confirmation from PSG that PIC had received its full allocation of IO shares worth 4.291 billion rand. Investment Administration Division contacted Mr. Siani to document that PMC approval has not been received yet for the above allocation.
Thank you, Mr. Commissioner. We may take the lunch agenda.
We'll adjourn until 2.
Yes, Mr. Commissioner.
Take it. Sorry? No, I'll go to the board. Actually brought lunch, but I don't know if I can make it.